Welcome to the P.I Show, that is, the Personal Injury Show. My name's Harry Nowicki. I'm with Tony Carbone. We're both lawyers and we are both involved in personal injuries, and the show is here to talk about injuries, people's claims that go before the court, and compensation and damages that people obtain through the court process. Tony, you've been a lawyer for
25 years.
25 years. I've been a lawyer for 24 years. We're both passionate about common law. We both are involved day to day in matters of common law. I don't think people appreciate what they have in Victoria and what's under threat. My opinion is common law is under threat from all sorts of forces. Terribly important that people appreciate they have common law rights if they're injured.
I think it's critical that people do keep their common law rights, because until you're actually in a situation where you've been injured and you're out there looking for someone to recompense you for your losses, you're out of work and you're losing money,
You've got medical expenses.
There's pain and suffering, loss of enjoyment of life. And once you lose that, you realise that, but you don't realise it until you've actually lost it.
So, as I say, in Victoria there's common law for work injuries, transport accidents and public liability. The governments in Victoria have, over the years, whittled away at common law and made it more difficult, but there still is common law in Victoria, and we're here to talk about cases that happen from time to time regarding common law.
Well, Harry,
rights.
What they've done is they've put upper limits on what you can get for pain and suffering, and also loss of income. The reason they've done it is because you're getting verdicts by juries all over the place. So this way it gives you some sort of a guideline.
Some uniformity.
Yeah, that's what they're trying to achieve.
Tony, one of the stories recently about common law and people's common law rights is the very sad history of asbestosis in Australia. James Hardie was a leading manufacturer of asbestosis sheets, and they've faced the court recently about misleading the stock exchange when they announced a special fund they were setting up to compensate people. Now, asbestosis, there are thousands and thousands and thousands of cases that have already been before the courts, and we're anticipating many more thousands. It's Australia's biggest industrial disease, and sadly it seems to be on the increase.
Well, Harry, people think that it's just an industrial disease, but it may pick up mothers, fathers, children, etc.
Anyone who's been exposed domestically to asbestosis, but it's mainly affected people who've worked with asbestosis over many
until
years.
Now. But
James Hardie set aside a fund, and everyone is worried that the fund may run out, and I think eventually, if that happens, the government will step in some shape or form. But it's something that people have been exposed 30 years ago. They see a doctor today, they're diagnosed with asbestosis or mesothelioma, and also, then they have to do something.
There's been a lot more incidents these days of homeowners with the mesothelioma. I can't say the word myself, but it's becoming more and more prevalent. The thing is, people that have been exposed to asbestos should probably get a check every 5 years, and that's what doctors recommend.
So anyway, that's Australia's biggest single claims over many, many years, and as I say, it's just been in the news recently with the James Hardie directors being found guilty of misleading the stock exchange about the fund they set up. Tony, there's cases, are interesting because they throw up interesting facts. And the first case we're going to discuss is someone called Sherry Willis, a 27-year-old receptionist who's working at a gentleman's club. She was faced with a patron who had a gun and came in and threatened her, left, then came back, threatened her again, I think left a silver bullet at reception.
And said that was for her.
That was for her. She was terrified She fled to the back, and she's now lodged a claim for stress, and that's before the courts at the moment. How do you see that case?
Well, what happened there was, before she got permission to lodge this claim, she had to get a serious injury certificate from the Work Cover Authority, Victorian Work Cover Authority, and or she had to go to court and get a judge to say that she was seriously injured. So that happens quite often. What she's got now, she's got a claim for pain and suffering and loss of enjoyment of life, and also a claim for loss of income. Now, her loss of income doesn't have to be total. She can be a partial loss.
But Tony, what does she have to? What does she have to do to resolve the claim?
Well, she's got to bring proceedings before the court. She issues what they call a writ, and then there's conferencing processes in place, and there's offers and counter offers, and then you've got to have a mediation before it goes to trial. Most of these cases do settle out of court. In fact, in Victoria, probably 90% of claims do settle out of court.
So there's a claim which may settle out of court. Why is the employer liable? It's a stress claim. There's no physical injury. She didn't sort of damage herself physically, but she's been traumatised. She says she has nightmares and can't work. Why is the employer at fault in this situation?
What happened in this case was that the fellow that put the gun to her head wandered off and then came back and then put the gun to her head again. So I think what should have happened is the employer should have closed the premises or at least rung up the police. If they had notified the police, they could have been on the lookout for this fellow. But look, I would have thought you'd close the premises in those circumstances. But
or
the fact that they did not...
extra security. I think she's
step up security.
Step up security. And I think, as I say, she was traumatised, and she's brought proceedings against the employer. And I think there's a security company providing security, so she's brought proceedings against both the employer and the security company.
I think it was pretty reckless on the part of the employer and the security company not ringing the police, because they exposed the general public at risk. I mean, this fellow's brandishing a silver gun out in the immediate vicinity. Who knows where he went? I mean, he could have shot anyone. Let's be realistic.
So there's a lot of, as you know, in Melbourne, there's a lot of nightclub violence and criminal activities. This is a criminal activity, if you like, someone coming in threatening someone with a gun. So that's assault. I think he's been charged with that. But she says that the employer is at fault. And I think we both think there is a reasonable claim. We both think it's arguable, and we think that
I think she'll win her case.
She should succeed or maybe settle out of court. That's all we've got time for at the moment. We're going to a break. We'll come back with some other cases and further discussions.